Hi guys, I hope you can hear me and see me. My name is Vedant. I am a lawyer practicing in Delhi. Today I want to discuss a little bit about this judgment, Bhumika Trust, which is more commonly known as the 3-year practice rule, 1-year practice rule judgment, which has come out just last week, where through which the Supreme Court has reduced the minimum practice requirement for people applying for the civil judge junior division exam from 3 years to 1 year. I know this judgment has helped a lot of people. बहुत लोगों का फायदा हुआ है उससे, but I personally stand uh, against the opinion and the view taken in this judgment. I find myself agreeing with Mr. Justice Vinod Chandran, who has taken a dissenting stand in this, and I'll explain to you why. I'll explain to you why this judgment takes an incorrect view, and why the 3-year minimum practice requirement was a very good step and a very good judgment that had been given in 2025 May. So, with this context, I'll take you through this judgment and I'll tell you some glaring flaws that this judgment has made while coming at this decision. So, a little bit of context before we start. For very long, there was no practice requirement, and the problem with practice requirement is that in India, state judiciaries are not controlled directly by the Supreme Court. And how that happens is because if you read the CRPC में sessions judge is supposed to be the highest judge in criminal law. उसके ऊपर of course it is supervised by the High Court, but sessions judge only is subordinate to the High Court. There is no mention of Supreme Court being the supervising body of the sessions judge, etc. So in every state in India, the conceptualization of judiciary is such that there is one Supreme Court and there are multiple High Courts, and these High Courts are the highest entity in the state. So therefore, the High Court has the onus to look at appointments, to look at staffing in these judges, in the lower judiciary. The Supreme Court does not really enter into that. तो इससे हो ये रहा था कि every High Court, every state in India had its own mechanism, its own procedure of appointing judges. Most High Courts appoint judges, and in some states, it's the Public Service Commission that appoints judges. So every High Court has its own rules. Some say कि we'll take applicants only who have at least 1 year of practice. Some say that we'll take applicants who have at least 3 years of practice. And there was a lot of difference between the way states were appointing their junior most judges. In view of this, and this was challenged before the Supreme Court, saying that अगर ये चलता रहा, we are not really maintaining a uniform method. There's no uniform mechanism of appointing judges in the lower judiciary, and that is not fair. And it's not fair in the sense even between applicants of different states, but it's also not fair to the people of that state. For example, I know for a fact that Rajasthan judiciary takes allows people who are even in their final year of law school to apply for their exam. But then there are states which apply, like Delhi, which require their applicants to have at least 1 year of experience practicing law. But there's already a difference between them, and this is arbitrary. There is no reason. A judge is a judge in the lower judiciary, and he needs to be appointed equally. There is no reason to have a difference between these two. So when this came in light, the Supreme Court said that no, this is not right, and it made a mandate of a minimum requirement of, I believe, 3 years, which I will point out right now. Yep. So if you read this right here, the second IJA judgment, which is the All India Judges Association, which is this right here. If you read this, you'll notice that in this case, which is from 1993, the Supreme Court held that in order to appoint civil judge, the lowermost rung, civil judge junior division, आपको 3 years minimum practice चाहिए होगा as a lawyer, and that was made as the essential criteria. This was back in 1993. This is the second All India Judges Association case. Everything was well, ठीक है, सब कुछ सही जा रहा था. Then in 2002, we had the third All India Judges Association case, AIJ, the third case. And इसके पहले दो और चीज हो गए थे. We had something called the 117th Law Commission report, and we had something called the Shetty Commission. So now, when the Shetty Commission came up, it gave its judgment. It gave its report in 1999, and it said that ये जो 3 year का practice rule है, we don't really need it. And वो ऐसा इसलिए करते क्योंकि they said that look, पहले जब हमने 3 year का बनाया था rule, then law की degree used to be only 2 years. You notice this? Back then, it was made at a time when the law course, LLB course, was only 2 years. So therefore, the requirement of judges to have experience was much higher then. But अब ये वैसा नहीं रहा है. Now we have law degrees which are 5 years itself. ठीक है? And the LLB course itself is 3 years, which happens after graduation. So there's already a lot of studying, a lot of वो already बहुत considerable experiences ले चुके होते हैं by the time they enter into the workforce. So we don't really need this. And this was the Shetty Commission's report in 1999. इसके बाद आया था हमारा 117th Law Commission report, and that was specifically on the training of judicial officers, which said that the 2 year intensive training would outweigh the advantage, if any, of 3 years practice. And here is where the debate starts. क्या आपको is practice that important? Can we not have a training module which is good enough to train judges after their appointment? ये इस question, this is the fulcrum of this whole dispute. Can we not appoint judges who are very young and then train them to be judicial officers instead of having them to have had a practice of 3 years or 1 year and then let them come into the judicial services? So these were the two things that happened before the third judge's case. And then in view of these two, in the third judge's case, which is in 2002, in the third IJA case, the Supreme Court said that there is no minimum requirement at all. So it became zero. And this is what happened. The mandatory 3 year rule was reversed. It was removed, and this was in 2002. So from 2002 till 2023, I believe, when this was finally in review in 2005, people started noticing that these judges that were coming in, who were 1 year graduates, not even graduates, maybe sometimes, and I said, as like in certain states of Rajasthan, you can apply if you're a final year student. If you have your 8th semester, 9th semester mark sheet, you can apply. But then there are states like there may be states. I know for a fact in Delhi, you needed a requirement of 1 year at least. There are other states which required you to have at least 3 years experience, and therefore ये practices differences होने लगे क्योंकि the 3 year mandatory requirement was removed. So when these differences came up, a lot of litigants started saying, a lot of advocates started saying, and even judges in the judiciary, lower judiciary, started complaining about the conduct of these judges. Or conduct, inka, what was different? What was different about these new judges was that they didn't know how the judiciary functioned. They didn't know how to deal with litigants. They didn't know how to deal with lawyers, the bar, and that is that's a very stark difference that you will have once when you compare a judge who has come directly into the judiciary with someone who has experience at the bar. And यही क्वेश्चन हुआ था. If you notice, ऐसे जजेस के टेम्परामेंट में डिफरेंस था, इनके बिहेवियर में, in their disposition to the staff, there was a lot of difference. And therefore complaints चिट्ठी पे चिट्ठी लिखी गई हाई कोर्ट्स को, सुप्रीम कोर्ट को, कि this is concerning, we want these judges to be out. And इन सब के व्यू में फिर in 2025 the Supreme Court took up a review of the third IJA judgment, and that is again been reviewed here. So when this judgment was reviewed, the third IJA judgment was reviewed, Supreme Court said that nahi, nothing doing. These judges are not right. They are not fit for us. They are not fit for the judiciary, and therefore we will impose a 3 year mandatory rule. And I'll just show you where and why that has come up. Exactly. So please read along with me on this. It was noticed that with no exposure, since they had no exposure of the court environment, they knew nothing about the culture, etiquette, and temper and conduct of court proceedings. Nothing. And therefore, it was removed. And now I want to just point out para 20. We'll come back to this and I'll tell you why this is important. But in view of this, the 3-year mandatory practice rule was brought in 2025, and I believe May. And now here is where the dispute starts. Now let's take a look at why this judgment has come. Okay? Now this is the background. Now we are looking at this judgment specifically. If you look at this judgment has been the last judgment had come in May 2025. After May 2025, a writ was filed by this institution called Bhumika Trust. ये तो यहाँ पे है. Who is Bhumika Trust? Bhumika Trust is an NGO which works in the interests of handicapped people. ठीक है. अब जब ये जजमेंट आया, तो when this judgment came, this trust filed a writ saying that 3-year requirement तो आपने कर दिया है सबके लिए, बट मैं जिन लोगों को रिप्रेजेंट कर रहा हूँ, these people need a lesser requirement. क्यों? क्योंकि ये डिसेबल्ड है. नाउ इन द सेम वेन, जिस तरह से हम शेड्यूल कास्ट, इकोनॉमिकली वीकर सेक्शंस को कुछ कंसेशन देते हैं, भले मार्क्स में हो, उनके एप्लीकेशन की फीस में हो, जिस भी तरह से हो, दे वांटेड दैट 3 year टू बी reduced and if possible removed. They are saying that they wanted that the 3-year practice rule was dispensed with in respect of the disabled people. और ये तो हो ही गया. अब while this was being heard, review petitions were also filed against the earlier judgment, which is in May, जो आया था. And these review petitions that were filed against the 2025 judgment, which had said 3 years, were also notice was issued in it, and they were asked to be listed along with this writ, जो ही भूमिका ट्रस्ट वाला है. So in this judgment, we have these two things. पहले तो someone who's filed a writ independently of that judgment, and then there's one which has filed there's one group which has filed a review petition against that judgment. They were all tagged along, and उन सब की hearing एक साथ हुई है. Now I want to take you through a little bit through the arguments that the petitioners have raised in this case. Please bear with me. I am switching between two devices. Therefore, that's the reason for the lag here. Yes. So what is review? What is review? First, let's look at that. And now from here onwards, I will tell you why I believe the judgment is wrong. So review jurisdiction. After judgment has come into picture, there are 2-3 things you can do with it. You can either appeal it, or you can have it reviewed, or you can go for a revision, depending on what is available to you, the rights available to you. Now, when you file an appeal, in an appeal, the judgment is relooked on its merits, meaning every finding that the judgment has recorded will be reviewed, will be checked, it will be evaluated on its merits, on its own. On the other hand, if you have the only option available to you is a review, when you file a review, the court will look at the judgment and it will see if there's any error apparent, if there's any prima facie error on the face of it in the judgment. If there is nothing of that sort, the review will be dismissed. So what is the meaning of error apparent? What is the meaning of prima facie error? There are judgments जहाँ पे recording कुछ हुआ है कि the petitioner said so and so, this was this and this and that, respondent said that, and therefore we took this view, but finally conclusion में something else is recorded. ठीक है? So this is an error apparent. Now, if this was not clear, let me explain to you in even more clearer terms, but a little, I'm going to stretch this a little more. Let's say the judge says, Upar ki, in order to decide so and so, we understand it has to be 2 plus 2. And then at the end, in the conclusion, the judge says that in view of these arguments, we decide that 2 plus 2 is equal to 5. Now, 2 plus 2 to वहाँ भी लिखा था, that we know. But we know that the conclusion is 5. So this is an error apparent. When you know that there is a glaring error जो दिख रहा है, that is the only scope of review. A review cannot go into merits of the judgment. कि क्या ये सही था? Was that opinion itself, was that view itself correct or not? That the judgment cannot look at. It can only see if there's any error apparent जो मतलब जो बिल्कुल दिख रहा है judgment में. Arithmetical error, clerical error, these kinds of errors are looked into in review. Nothing else. So now, what is the, if you look at, so I think this judgment has been written by Mr. Justice Suryakant. Let's just look at that one. Yes, it's authored by Mr. Suryakant. So the reasoning that Justice Suryakant gives for opening this review itself is that in the previous judgment, the court did not decide the question of I'll just take you to that para. If you look at this, uh, yes, the argument that Miss Pinky Anand was raising, senior advocate was raising, was that review judgment ने consider ही नहीं किया कि was 3-year practice rule the most effective, yeah, it had any alternates. And this is what she's saying. She's saying that the judgment under review did not sufficiently consider whether prescribing 3 judges was the most effective means. That's the only contention. Now, इसी basis पे the judgment proceeds. And that is what is again reiterated here, that needed to improve, the judgment under review did not adequately consider whether the same objectives could be achieved through a shorter period of practice supplemented by training after selection. That is their main concern. Did the judgment under review decide this? Now, in context of what I've explained to you on the scope of review, do you think this is right? I don't think so. ये क्वेश्चन रिव्यू में देखा ही नहीं जा सकता है, ये देखा ही नहीं जा सकता है. दिस इज मच बियॉन्ड द स्कोप ऑफ रिव्यू. रिव्यू का स्कोप बहुत छोटा है, एंड द क्वेश्चन दैट्स बीइंग रेज्ड हियर इज जस्ट सिंपली ऑन मेरिट्स कि डिड द जज डिसाइड दिस करेक्टली, क्या कोई ऑल्टरनेट मेथड्स थे. एंड on that I also want to now go back to para 20 जो मैंने पहले पॉइंट आउट किया था आपको. If you read para 20, this is not even the arguments of the petitioner. Arguments तो चलिए वो तो petitioner raise करेगा. But what does the judge say on that? So judge has clearly said that there can be no gainsaying. Now there is no dispute that this court did not arrive at that conclusion, which is the 3-year mandatory rule, without weighing what would be lost by it. It expressly acknowledged that in the initial years, the opportunities available to a young graduate fresh from college would be minimal. So now in that light, Mrs. Pinky Anand's argument that the judge did not consider this adequately is not a fair argument. जब ये हमारे Mr. Justice Suryakant is already saying that there is no dispute that this court had already studied this point. It had already studied that what would be lost if we allow 3-year mandatory practice rule. जब ये consider हो गया है, there is no scope left. That means that argument does not stand. So the ground for review does not stand. So now, and that's one problem that I have pointed out. Uh, okay, this is one thing. Now I want to take you to the small quote from the previous judgment. Okay? This is the portion that I want to point out. Issue number 7. There were a lot of issues in there. I think there were 7. I think there were 10 or 12 issues in the previous judgment. Issue number 7 in that judgment was this: whether the requirement of having a minimum 3-year experience, minimum 3-year practice for appearing in the exam of civil judge, which was done away with, in this case, needs to be restored, and if so, by how many years? So this has already been in question. The question was two things: the minimum requirement of 3 years, do we need it to be restored, and उसके बाद, is it 3 years only that we need, या will 1 year suffice, or will 2 years suffice? So this was the dispute already. So now मैं again summarizing my argument. Mrs. Pinky Anand raises the argument that review करना पड़ेगा, क्योंकि ये question कभी उस कोर्ट ने डिसाइड ही नहीं किया कि is 3 year mandatory, is 3 year required, या are there any other alternates. Now what I say is that ये तो issue में था ही, the court looked into this issue, was framed कि do we need so and so number of years. In addition to this, Justice Surikant has also mentioned that उस judgment में already acknowledged था ये, they took into account 3 years से क्या नुकसान होगा, क्या फायदा होगा, they've looked into it. So now that is done. Now the second thing we need to keep in mind is ये जो judgment आया है इसके पहले in May 2025, to review it is simply it amounts to a mockery of high courts. जब हमने पिछले साल जजमेंट आया था, तो कोर्ट ने ऑलरेडी सारे हाई कोर्ट्स को कहा था कि आप एक एफिडेविट सबमिट करिए टेलिंग अस कि व्हाट डू यू थिंक अबाउट मिनिमम रिक्वायरमेंट, हाउ मच डू यू वांट इट. तो उसमें ऑलमोस्ट यूनानिमसली all high courts had said that we need 3 years. Simple. We need 3 years. Except for, I believe, Rajasthan, which had said 0 years as its practice, and Delhi, I think, which had said 1 year, and Sikkim, I believe, which is also said 1 year or 0 years, I can't remember. So we have already taken high court's judgment. So now look at the strength of this judgment. There is a judgment here which looks into the practice and the complaints that have been raised before it. कि लोग, इनके टेम्पर खराब है, इनका कल्चर खराब है, इनका प्रैक्टिस खराब है, इनका बिहेवियर खराब है कोर्ट में. इट लुक्स एट दैट एंड देन इट कॉल्स फॉर हाई कोर्ट्स कि देखिए भाई, आप ही सुपरवाइज कर रहे हो इन सबको, यू टेल मी व्हाट डू यू थिंक इज बेस्ट. एंड वंस दे से दैट नहीं, वी नीड 3 years, इट्स डन. दिस हाई कोर्ट सेज ठीक है, द सुप्रीम कोर्ट सेज ठीक है, इफ यू थिंक इट इज गोइंग टू बी 3 years, it should be 3 years. That's it. If you can't reach there, if you don't know what's happening in the lower judiciary, invite affidavits. It did that and it was decided. Now, extremely weird, but this judgment in review, जो अभी review decide हुआ है, उसमें दोबारा every high court and law schools, law universities were asked to send their affidavits of what they think the practice requirement should be. पहली बात तो, we already have this question decided. In the last judgment, you already had invited affidavits from high courts saying on this same point. So you already have it. You already have their opinion. You have it. You know their opinion. But आपने दोबारा वही process किया issue. ठीक है भाई. Again you give affidavit. And this time you've also included, I believe, only NLUs, not even law schools, only NLUs. Yes. We also have the advantage of considering the affidavits of high courts as well as law universities and national law schools. This is it. Now, why should national law schools say anything but 0 years? Why should they say anything? You're inviting the interests to be considered of a party. which has almost no role. They are supplying students and they would only want the best for their students, and they will say 0 years. In fact, you ask them, they'll say, look, you can take our fourth year students also and train them for the final year. We'll give them full marks here. You don't care about it. आपने नेशनल लॉ यूनिवर्सिटी से, लॉ स्कूल से क्यों मांगा रिकमेंडेशन? वो क्या देंगे आपको? वो तो यही बोलेंगे कि हाँ, यू टेक दिस, यू टेक देम इन फोर्थ ईयर इटसेल्फ, आप फाइनल ईयर में कर दो अपीयरेंस, not even 1 year. They'll 100% they'll say that. There is no need for you to give them any experience, for them to have any experience. Please take them right after they graduate. I am certain almost all law schools would have said that. High courts on the other hand maintained their position mostly, क्योंकि उन्होंने तो लास्ट टाइम फिर से दिया था. If had they wanted, they could have, वो they चिपका देते वो same affidavit. They've already given their affidavits. It was already on record last time. So now, again, that was asked. No reason. This is just, I just wanted to point this out. No reason at all to again repeat this process. But anyway, it was done. And now, voila. Take a look at this. Look at this. The law universities, law colleges, and members of the bar address themselves more directly to the duration of the requirement, and a substantial body of that opinion favored a period shorter than 3 years, coupled with a strengthened training of regime of training. Exactly what I said. You ask law universities ki how many years of experience should candidates have, they'll say zero. They will say zero. There is no doubt about it. They will say zero. There is no need to even ask them. जब वो judges appoint नहीं कर रहे हैं, why are you asking them? There is no need to ask them. And now I want to bring you to the amicus judgment. Amicus is recommendation in this case. Okay? And before that, I'll take you to one observation that I have. When you have judgments of this type, जहाँ पे there's one group which is there's no right or wrong here. I'll tell you why. ये चीज कहना कि आप प्रैक्टिस करके आओ फिर यहाँ आना, या ये कहना कि आप पहले आ जाओ और हम आपको ट्रेन करेंगे. I find myself swaying between both these sides. I think that the 3-year practice rule is required. It is required. And not just being enrolled for 3 years, I want every candidate to show that they've at least made 20 appearances, 30 appearances, 40, whatever the court finds fit. कितने appearances हुए हैं उनके. They have appeared. And they need some way to prove that they're very well acquainted with the practice of the lower judiciary. अब अगर आप ये कह रहे हैं कि I'm sorry, अगर आप ये कह रहे हैं कि there's one group which says that 3 years का minimum requirement है, you need to have 3 years, and one group which is students like us, students like all of us our age, who say that नहीं, zero, बिल्कुल zero, -1 if possible, zero. And I say -1 because Rajasthan was allowing students in their final year itself, so they will try to take it as low as possible. In cases like this, जहाँ पे issues need to be decided in या तो right या wrong, you can't have a mediation kind of setup जहाँ पे आप लें कि अच्छा ये 0 बोल रहे हैं, ये 3 बोल रहे हैं, हम दोनों को ऐड करते हैं, डिवाइड बाय 2 करते हैं, अच्छा ठीक है 1.5, we'll say 1 year experience. You can't do stuff like this. If any of you have sat ever in Mr. Arvind Kumar's court, Justice Arvind Kumar's court, he used to sit with Justice Prasanna Varale, I believe in court 13-14, at least until May. I don't know who he sits with right now. If you sit in their matrimonial dispute after matrimonial dispute, and उनका एक formula था, he would ask the husband कि how much can you give, he'd ask the wife कि how much, what is your ask, ठीक है, and naturally ask ज़्यादा होगा और giving का limit कम होगा, तो he would say, look, you either arrive at a decision right now, how much are you going to come to, या फिर we have a formula, we'll take your demand, we'll take your amount that you can give, we'll add it, we'll divide by 2, and that's his standard practice. Wife is asking 60, husband wants to give 40, he'll add 50. Now ये प्रैक्टिस यहाँ नहीं आ सकता, ये नहीं आ सकता कि हाई कोर्ट 3 साल चाह रहे हैं एंड बच्चे 0 years मांग रहे हैं तो आप ऐड करो, अच्छा 1 year. This can't work, this cannot work. दिस इज नॉट अ मीडिएशन काइंड ऑफ सेटअप जहाँ पे आप दोनों पार्टीज का ये देख लें कि वो आर बोथ ऑफ देम मॉलिफाइड, ठीक है दोनों, अभी नहीं कर सकते. नाउ आई वांट यू टू कम टू amicus require the amicus suggestions, ठीक है. The one thing that we have to keep in mind, even with all this sharp criticism for this judgment, is that आप अगर आप ये देखें कि there are students who prepared for almost a year only to see that, oh shit, this rule is gone. अब I need to sit for 2 more years and only then I can give the exam for judiciary. उन लोगों के लिए we need some special requirement that I cannot stress more. We need that. क्योंकि these students were reasonably expecting that, look, I'm preparing, I'm going to coaching, I'm doing this, I'm doing that, and then ekdam se one day you take away all of this and you say that nahin, now whatever you've done, wait for 2 years and only then you can apply. It's not fair for them. It is not. So now in that context, this guy gives 4 recommendations. Is Siddharth Bhatnagar, senior advocate? I believe he's senior. Yes, he is senior. He gives 4 suggestions. First, he says ki ya to we'll keep 3, ya to we'll remove all 3, and then he says that there's one more requirement, that there's one more method. He says that we have a staggered transition under which the recruitment would be phased in over the next 3 recruitment cycles, which nil, 1, and 2 years of practice respectively for 26, 27, and 28. And then it be made uniform. This, I believe, there is nothing better than this. Nothing better. This is the best suggestion that you could give, and this should have been followed. This has been followed mostly. This is what's been followed. Except ये जो कह रहे हैं कि आप 3 बैचेस में डिवाइड करिए, 0, 1, 2, 3 and then उसके आगे से यूनिफॉर्म. This judge has just said that, look, हम 1 साल के लिए आपको एग्जाम्पशन दे रहे हैं. For 1 year जो भी पहले तैयारी कर रहे थे वो अपीयर हो जाएंगे. For all those applications जो 2027 अप्रैल तक आने वाले हैं उसमें तो आप अपीयर हो जाएंगे. बट इन ऑल एप्लीकेशन जो 2027 अप्रैल के बाद आएंगे, in that you will require 3 years. Simple. Not very good. Nothing at all will beat this. This is just the very best. You make 3 categories and then you make it uniform. Now one more thing that I want to point out. आप इस जजमेंट को जब पढ़ेंगे, you will undoubtedly feel like there's one compassionate ground तो जजेस प्ले करना चाह रहे हैं कि, आई एम सॉरी, नॉट प्ले, एक कंपैशनेट ग्राउंड जो जजेस पुश करना चाह रहे हैं जजमेंट में, वो ये है कि लुक, वी अंडरस्टैंड कि लॉ में एंट्री लेवल में बहुत स्ट्रगल है, बहुत कम पैसा है और बहुत प्रॉब्लम है, ये है वो है. सो वी डोंट वांट मेरिटोरियस पीपल टू लीव, वी वांट देम टू स्टे एंड वी वांट देम टू गेट एब्जॉर्ब्ड इन जुडिशरी एकदम स्टार्टिंग में. तो बेसिकली वी वांट, उनका एक आर्गुमेंट ये भी है कि वी वांट द रिक्वायरमेंट टू बी लो सो दैट ये जो स्ट्रगल कर रहे हैं ना लोग कि मैं लॉ पढ़ लिया मैंने, मैं क्या करूंगा अब, मुझे कहीं प्रैक्टिस भी नहीं मिल रहा, मेरे चेंबर में 10,000 दे रहे हैं, 15,000 दे रहे हैं, व्हाट डू आई डू, लेट मी अपियर फॉर जुडिशरी, लेट मी फिनिश प्रिपेयरिंग, लेट मी अपियर फॉर दिस एग्जाम, लेट मी क्लियर इट, एंड ये सारा स्ट्रगल खत्म हो जाएगा. तो नाउ एंड आई विल रीड दिस पैरा टू यू नाउ. फॉर इंस्टेंस, young advocates, particularly those without established professional networks or financial support, may find it difficult to sustain themselves for several years in a profession in which the initial years of practice frequently provide less or no assured remuneration. Compassion. Oh shit, if we don't give judges, if we don't allow kids to enter this, what will they do? वो तो स्ट्रगल करेंगे, उनको पैसा नहीं मिलेगा, उनको ये नहीं मिलेगा, वो नहीं मिलेगा. In that same vein, ऐसा ही कुछ रेज किया गया है वुमेन एंड ये सोशली बैकवर्ड कास्ट के लिए. वुमेन especially may face additional social and familial constraints during the period in which they are expected to establish themselves at the bar. Similarly, persons with disability may face difficulties in obtaining meaningful opportunities for practice at the bar. अब ये कहना चाह रहे हैं कि इफ वी डोंट अलाउ दीज स्टूडेंट्स जो पुअर फैमिली से आ रहे हैं, जो फाइनेंशियली स्ट्रगलिंग फैमिली से आ रहे हैं, टू कम इन, if we don't allow women to come in, if we don't allow people who are disabled, handicapped to come in, it's not fair to them. No, I am not moved by this argument. Or it's in that he's given a similar argument on the top. I don't remember the para number. Jabi says that if we don't allow women to become judges at a young age, if we allow this 3-year practice rule to come, 23 के age में they graduate, plus you add 1 year for preparation and 1 year buffer, that makes plus 2 years, and you add 3 years practice requirement, that adds 28. So you will have a woman who's becoming a judge finally at the age of 27 or 28, by which in India, being India, women often face the pressure of being married. This is his argument in it. He has said this above. I don't remember the para number. He has said this. अब it's right. I will not even. There's no point in disputing it. ये बात सच है. एंड ये बात भी सच है कि बहुत स्ट्रगल है इस प्रोफेशन में. ये बात भी सच है कि डिसेबल्ड लोगों को ज़्यादा स्ट्रगल फेस होता है. ये सब कुछ सही है. एवरीथिंग इज राइट. बट if all of that is right, does that push the argument of having a minimum, bilkul zero requirement? Does it beat all the requirements of 3 years? What I want to say is that just because these people are at a disadvantage, क्या इनको हेल्प करने के लिए हम जजेस के मिनिमम रिक्वायरमेंट को जीरो कर दें या 1 कर दें? एंड व्हाई आई से दिस इज, ये जो प्रोफेशन है जज का, ये एक प्रोफेशन नहीं है. एंड दिस हैज बीन रिकॉर्डेड बाय मिस्टर विनोद चंदन आल्सो इन हिज जजमेंट. ये एक प्रोफेशन नहीं है. सरकार का बहुत सारा जॉब है. इट प्रोवाइड्स अस इलेक्ट्रिसिटी, इट प्रोवाइड्स अस गैस, इट प्रोवाइड्स अस वाटर. बहुत कुछ होगा, बहुत कुछ होगा. उसमें से एक ये भी है कि वो हमें जॉब दें. विच इज़ वाई एवरी फ्यू ईयर्स पीपल कम अप विद प्लाकार्ड्स की नौकरी कहाँ है, जॉब कहाँ है, ये वो. बिकॉज समवेयर और द अदर वी बिलीव दैट गवर्नमेंट का काम है कि हमें जॉब मिले, टू कीप अस एम्प्लॉयड. बट क्या वो सारे जॉब्स में? आई डोंट थिंक सो. आई रियली डोंट थिंक सो. आप प्यून, क्लर्क, ड्राइवर, ऑर्डरलीज बहुत कुछ अपॉइंट करते हैं. एंड मे बी देयर यू कैन फिल अप योर, जो एम्प्लॉयमेंट का है ना कि वी आर क्रिएटिंग एम्प्लॉयमेंट, सब कर सकते हैं. बट व्हेन यू आर अपॉइंटिंग जजेस, इसलिए नहीं कर सकते कि ओ शिट, इफ यू डोंट अपॉइंट अ जज, there's going to be people who are going to be disadvantaged. Yeah, there's going to be people who are going to face some problem. इसलिए let's appoint judges. This cannot be a consideration in appointing judges. In my opinion, you need to have judges who have at least 10 years of practice, 15 years of practice. There is no reason to push the bar down at all. 10 साल practice, 15 साल practice. अगर इतनी जनसंख्या है देश में, we need to have only the finest. Why are you reducing it? Just because someone needs a job? No. वो ढूंढे. क्या उसे ये नहीं पता था तब कि लॉ में स्ट्रगल होने वाला है when he joined this course? I don't care if he's a bright legal mind. I just don't care. Does he have the experience at that age? He doesn't. The brightest legal mind, put him there, he's going to struggle. He doesn't know the practice. He doesn't know how things function. How is he going to do it? He can't. And on the same place, you bring someone who has 10 years, 15 years experience. He sits there only because uske CV में, uske life में, this adds prestige. He's a judge now. He's going to retire as a judge. You bring him in, and I can assure you, by virtue of his experience, by virtue of his practice, he's going to do a much better job than a 1 year, 2 year old kid in the same place. And I will repeat and I'll end it here कि you can't, in considerations में आप नहीं ला सकते जॉब कि ओ शिट, ये लोग स्ट्रगल करेंगे, इन्हें पैसा नहीं मिलेगा, the ladies they'll be forced to get married. These are not considerations to appoint a judge. With all respect to all these concerns, they are very true in themselves, but एक जज का नौकरी वो ड्राइवर नहीं है. जज इज नॉट अ ड्राइवर, जज इज नॉट अ ऑर्डरली, इज नॉट अ कुक, इज नॉट अ गवर्नमेंट गार्डनर, इज नॉट अ गवर्नमेंट क्लर्क, प्यून. इज नॉन ऑफ दोज. ही हैज अ वेरी डिफरेंट फंक्शन. उसके वहां बैठने से लोग सफर कर सकते हैं अगर वो गंदा होगा. एंड अगर इतना इंपॉर्टेंट है, यू कांट जस्ट ब्रिंग, इतने इंपॉर्टेंस वाले जॉब में यू कांट ब्रिंग कंसिडरेशंस लाइक दिस कि ओ ही इज गोना स्ट्रगल, ये होने वाला है, वो होने वाला है. यू कांट डू दैट. and I just read this out कि इतना struggle होने वाला है इन सबको, तो let us just bring more judges, है ना? Let's make more judges because इतना struggle है lower rung में. Not right, not the right way. हाँ, तो this I already pointed out कि जो अब this is also a little tricky. The court says that हम ये नहीं कह रहे हैं कि लास्ट जजमेंट गलत था, हम ये नहीं कह रहे हैं कि हम अपने फाइंडिंग से सप्लांट कर देंगे पुराने जजमेंट को, एंड लेट दिस बी वेरी क्लियर. हाँ, please read this along with me. We therefore consider that the present exercise should not be understood as questioning the wisdom of prescribing 3 years of practice. What? You don't? You have just questioned the entire wisdom. That is what you have done. That's what you have done. Rather, it is an exercise in ensuring that the rule is implemented in a manner which is fair to affect those. Okay, now I see. आप ये कहना चाहते, let me just make this a little more clear. इनका ये कहना है कि we stand completely with the 3-year judgment that came last year. We are not questioning the wisdom. We are not questioning the wisdom. They made it clear. But we only want कि जो सफर कर चुके हैं from the sudden restoration, उनको sufficient time मिल जाए. सही में? If this was the only thing you wanted, आप कहते कि ठीक है, वो तो चलेगा, 3 year वाला रूल तो रहेगा ही रहेगा, बट जो 26-27 में अपेयर हो रहे हैं उनके लिए माफ हो जाए. That's it. You should have ended the judgment right there. You should have ended the judgment right there. Right there. If that's all you wanted to do. But आपने ये नहीं किया. आपने क्या किया? And how can this even stand? This is just this outright incorrect. That it should not be understood as questioning the wisdom. You have questioned the wisdom. You have called the affidavits of high courts and national law universities just to question the wisdom of the previous judgment. That's the only thing you have done. What? Anyway, and second thing, अगर आपको सिर्फ यही करना था, if you wanted to give sufficient time to all those people who have been affected by the sudden restoration, दे दीजिए आप. For the next recruitment cycle till 27 till 28 आप उसे माफ कर दीजिए. बट उसके बाद let the 3-year rule stick because you're not after all questioning the wisdom. यही तो आप कह रहे हैं ना, यही तो कह रहे हैं आप बिल्कुल यही कह रहे हैं. We are not going to question the system. We are not questioning the wisdom. Sorry, not system. We're not questioning the wisdom. If that is the case, don't question the wisdom. Anyway, that's that. We are now going to read. Oh, and this is one more concern I had, which I will come to a little later. Yes. This is Mr. K. Vinod Chandran's judgment, which I'll discuss after discussing one small point. आपने लॉ क्लर्क के जॉब को वैलिड माना है एज एक्सपीरियंस. अट शिट, आई डोंट एग्री विद इट. आपने जितने लोग सुप्रीम कोर्ट या हाई कोर्ट में प्रैक्टिस करते हैं, जज के साथ जो एक दो लोग बैठते हैं नीचे वेल ऑफ द कोर्ट में, वो लोग क्लर्क्स होते हैं. उनमें से कई सारे वो असिस्ट करते हैं कि अच्छा सर ये जजमेंट, ये केस आ रहा है कल, उसका ब्रीफ प्रिपेयर करेंगे, आर्ग्यूमेंट के नोट्स लेते हैं, ब्ला ब्ला ब्ला, ये सब चीज़ करते हैं. और कभी कभी उनका काम ये भी होता है कि रजिस्ट्री से कोऑर्डिनेट करना कि सारे फाइल्स आ गए हैं, ब्रीफ्स आ गए, नहीं आए, ये सब चीज़. ये सुप्रीम कोर्ट हाई कोर्ट में होता है. आई डोंट थिंक कि डिस्ट्रिक्ट कोर्ट्स में कोई प्रॉपर एलसी होता है. असिस्टेंट्स होते होंगे, स्टेनोज होते होंगे, बट आई डोंट थिंक देयर इज एन एलसी इन डिस्ट्रिक्ट कोर्ट्स. बहरहाल वट एवर द केस इज, ये बोला गया है कि अगर आप एलसी पे रह गए 3 साल तक या 1 साल तक, वन यू कैन बी अ 1 year एलसी एंड देन अप्लाई फॉर जुडिशरी एंड यूल बी एडमिटेड, यूल बी टेकन एज 1 year प्रैक्टिस. ये ऑलरेडी बहुत कंसेशन, ये पिछले जजमेंट में भी था एंड इट हैज बीन रिटेन इन दिस जजमेंट. आई डोंट थिंक इट इज राइट. LC experience doesn't count. It does not count. There's no वो काउंट करके कुछ नहीं होगा. You have to be experience at the bar should matter. Simple as that. ये जो हम pleasing कर रहे हैं students का, absolutely no, absolutely incorrect. In my opinion, clerkship should be removed. Only and only practice at the bar should be counted. Now, effort. Now let's go to Mr. Vinod Chandran's judgment, and I'll take you to the very first, most important point. Okay? The review of the judgment in IJA is sought only to the extent of it having provided 3 years practice as a necessary requirement. The arguments raised were omnibus, as if it was a proper hearing on the merits. But I confine my consideration to those relevant for a review. Now let's go back to the very first thing I said in this video. ये एक रिव्यू में है, ये रिव्यू में जजमेंट है, ये अपील नहीं हुआ है, ये अपील नहीं हुआ है. अगर ये अपील नहीं हुआ है तो हाउ कैन यू डिसाइड ऑन मेरिट्स? और मेरिट्स पे डिसाइड हुआ है भाई, आपने आपने दोबारा मांग लिया है हाई कोर्ट से अपना कंसिडर, अपना बताओ, अपना ब्रिंग मी योर पॉइंट्स. आपने एनएलयू से मांगा है, आपने ब्रिंग मी योर पॉइंट्स, आपने एडिशनल मटेरियल कंसिडर किया है. हाउ कैन यू देन से दैट नहीं नहीं नहीं, इट्स नॉट अ ये अपील नहीं होगा, वी स्टिल इन रिव्यू? हाउ कैन यू से दैट? You can't say that. And he's quick to point that out. For a review, there must be an error apparent on the face of the record. In my opinion, this would have been best considered by regular bench, क्योंकि of course भाई ये अपील नहीं है, रिव्यू है, ये रिव्यू है. There's no, you can't consider it by a bench sitting in review can't hear merits for a matter which is in review. It's not an appeal. Anyway, that's that. Last, I just want to take you to a few things he has said which are very strong. The requirement of experience is the need of the hour and essential in the immediate future. Otherwise, we would be accused of creating a cadre of careerists rather than of jurists capable of enriching a robust system, alive to the needs of the nation, society, and its people. And with that, I didn't expect my video to be this long, but with that, I bring an end to all I had to say about this judgment. Incorrect, just incorrect. And there are some glaring flaws which needs to be fixed, and that's why I don't agree with this judgment. Thank you so much for watching. Please reach out to me if there's anything I can help you with.